SJC-13825, Kevin C. Robinson versus Town of Marshfield.
Okay. Attorney Crowdy.
Good morning, Your Honors. Jason Crowdy on behalf of the Town of Marshfield. Would you like me to give an introduction?
Whatever you want to start with.
Okay, thank you. Two primary issues we'd like to focus on in this matter, Your Honors. First, in our view, the evidence for a verdict for the plaintiffs was insufficient. And second, the clear errors of law in both the jury verdict slip and the jury instructions should have resulted in a, if not a defense verdict, then a new trial. Just briefly on both points, this case was a matter that involved two female firefighters, were the only two people in the class. One was the chief and the chief's niece, the captain's daughter. The other was. Since
you asked,
sure.
Thinking maybe you should start with the instructions.
Sure. This case originally had been a age discrimination case. It was litigated that way throughout discovery. By the time we got to trial, there was roughly 10% of the case left. The trial lasted.
Can you go right to the mixed motive versus pretext instruction issue?
Sure. I guess where I was going with that, and I'll jump to it very quickly. Despite the fact that there wasn't much of the case left, over our objection, there was quite a bit of evidence that came into evidence where.
Did you ask for the mixed motive instruction?
So we had asked for at some point a mixed motive instruction, at some point a pretext instruction. What we knew under win and win was that it would ultimately be up to the trial judge to decide.
But when you were advising the trial judge on the instruction, you asked for both?
We did.
Okay.
We asked for either or. We wanted either a correct mixed motive instruction or a correct pretext instruction. I mean, we knew.
You never asked for this mixture, did you?
No. In fact, we adamantly opposed what we viewed as sort of a Frankenstein mix of both. It was something that we got quite boisterous with the trial judge over the fact that.
Well, regardless of boisterousness, you objected to having a mixed motive and a pretext instruction.
Repeatedly. Okay. And we took the position that, this simply was not the law, and this cannot go to the jury like this. And we were quite frankly overruled.
Why were you asking for a mixed motive instruction? Because that's usually. Well, go ahead.
Right. So this is kind of what and just bear with me for a quick moment. Right. This is what I sort of started to get into. Despite the fact that most of the 90% of the case in our view was gone, the trial judge, over our objection, allowed in a number of different things. And just quick examples. They allowed in evidence that the town administrator made a contact with the State Ethics Commission. They allowed in evidence that the town council and town administrator spoke with the attorney who they had hired to do what was consistently referred to as a sham investigation. They were allowed to discuss union grievances that they said were malicious, and that the town council asked the fire chief to retire. So there was all this evidence that was brought in, and quite frankly, I mean, mixed motive versus pretext is a pretty esoteric thing to begin with, never mind for a jury of lay people. And in our view, we knew it was a higher burden, but we knew we could meet that burden. And with all these other things that came in, I thought we needed to cover ourselves on whether or not this was ultimately going to go to the jury on mixed motive or pretext.
So you're saying you did actually request a mixed motive instruction?
We requested either or.
And as you requested either or, and you didn't push back on the idea that the mixed motive is very limited. It's when you're supposedly have strong direct evidence of discrimination.
Right.
And you didn't push back and say, this is not that kind of case. In fact, At summary judgment, the summary judgment motion judge said the opposite, that this was lots of evidence of supporting your view, but not very much on discrimination. So,
Right, so the issue in our view was that all these other things came in. And if a jury was allowed to hear them, it's difficult to determine what is what is direct evidence, what is indirect evidence. And it's difficult for an attorney, it's difficult for a judge, never mind with the lay people. So I think what we tried to do was say, look, if we're going to go down the mixed motive road, which we're happy to do because we know it's a higher burden, but we did in fact meet that burden. We had all 3 members of the Board of Selectmen testify unequivocally that the only reason they made the decisions that they made was because of the state ethics violations and because of poor morale within the fire department. They all said, and this was unrebutted, that they knew nothing about or did not consider any purported complaint of gender discrimination. So if it went in on mixed motive,
I'm not sure that's your strong. Can you address, the motion judge realizes the trial judge realizes he makes a mistake.
yes.
And then he says, this is a pretext case, and I should have instructed on pretext alone, not mixed motive and pretext, or at least jamming them together. He then says it's not prejudicial. You want to respond to that?
I don't see how it could have been any more prejudicial. It's simply not the law.
Can I ask this a similar question in a different way? The jury verdict form, do you agree that pretext is not an element of the claim? That's a yes or no question. Do you agree that pretext itself is not an element? There are 4 elements of a retaliation claim, and none of them is pretext, correct?
I'm not 100% sure I'm following what you're asking.
So there are 4 elements to a retaliation claim, and the judge's verdict form went through those elements, and one of those elements is causation. And the judge instructed this jury on causation. And as part of the instruction on causation, the judge instructed the jury that they had to find that the protected conduct by Mr. Robinson was a but-for cause of the ensuing adverse action. And the judge also, as part of the causation instruction, instructed that if the reasons given by the town were false, the jury could, if they could infer that that it was pretextual.
I understand.
And so the jury then, in the verdict form, said, and we assume they followed that instruction, that the plaintiff had proven causation. The verdict form that then went on, and you proposed the verdict form, although not all language in the verdict form. The verdict form went on to what the judge's instructions had said were a sort of, essentially the judge's instruction characterizes as a defense, that if the town could prove that it would have done it anyway for other reasons, et cetera. How do we deal with the fact that, assuming the jury followed the judge's instructions as we usually do, the jury found for the plaintiff on causation?
So on question 6 on the jury verdict form, the jury decided, they found that the members of the Board of Selectmen would have come to the decision that they did without any consideration of the purported report of gender discrimination. That should have ended the case right there.
No, well, but they'd already, a couple of questions earlier, found that the plaintiff had proven causation and which is part and parcel of the proper theory. What you're saying was the proper theory.
Correct.
And so how do we deal with the fact that the jury, as instructed by the judge, found your client liable on the proper theory, even though there's definitely confusion that ensues later in the verdict form?
So the jury verdict's inconsistent. And I think that just really highlights the fact that these instructions were not clear. They weren't clear to the jury on either the jury verdict form or the instruction. I mean, again, I think it's a really relatively complicated area of the law for lawyers and judges. But if you look at the verdict form, they found things that are inconsistent throughout the form. I mean, when they get to that question 6, and they find that these guys would have reached the same decision anyway, it's not consistent with other areas of the verdict form where they would have found otherwise.
But I realize you didn't propose all of the language in question 6 and 7, specifically the phrase or solely, et cetera, but your client proposed the verdict form that improperly went through both theories as opposed to just the proper theory.
So I think we submitted 4 different verdict forms throughout the course of the trial because it was a constant work in progress. And I believe, and I don't want to misstate it, but I believe the court even required us to submit one before trial even started. So, I mean, we don't know if it's going to be mixed motive. We don't need to know if it's pretext, but we're submitting jury verdict forms. And it was a product of back and forth with the trial judge, knowing that ultimately he had the say under win and win whether or not it was motive, a mixed motive, whether or not it was pretext, whether the evidence was direct, whether the evidence was indirect. So respectfully, I think it's difficult to say like what we submitted, we really kind of would have stuck to, because it was this back and forth, where between defense counsel, plaintiff's counsel, and the trial judge, we were continuously arguing about what the law is, what the instructions should say, what the verdict slip should say. And we got to a point where what was going to the jury, we were jumping up and down saying, this is not the law. This is just wrong, and it's not going to stand. And as soon as the jury verdict was read, the minute it was read and the jury left the room, the first thing the trial judge did, and it's on the record, is he went to question 6 and he read it and then was sort of confused, seemed to me kind of confused about like, how do we get a yes to question 6 and then we have an adverse verdict? And I think that really sort of highlighted, and what's the standard for a new trial, right?
Can I ask one thing?
Sure.
If this were done as a standard pretext case, you would have the pretext language in the elements or not? Justice Stewart's question sort of surprised me a little bit.
So there's no.
What do the standard instructions read in a classic pretext case?
So there's no model jury instructions for, and I think that's one of the big problems, right? So
Well, a pretext is a way to show causation, which is the element.
right, I'm just saying that there's no model jury instructions for.
The verdict form could have stopped after question 5, and then, which is causation, and then gone straight to the damages. In other words, 6 and 7 may have been surplusage.
I think the jury verdict form could have. I think if the jury verdict form were worded 2 or 3 different ways, we likely would have got 2 or 3 different outcomes. Our point is that ultimately it was not the correct statement of the law over our objection, something we were overruled on.
So how should the instruction, if you do this properly, and you say there's a lack of clarity out there and we should clarify it, is the earlier instruction without 6 and 7 the proper instruction in a pretext case, or is that confusing as well? Because
I think it's very confusing. I mean, we're dealing with essentially a footnote in the win versus win case in no model of jury instructions, and I think
This was not a mixed motive case. So the win versus win thing is an unfortunate aspect of what happened and what was introduced at the jury instruction stage. But in a garden variety pretext case, you would have a question about causation, and then have another question that follows up, sort of a sub question that would say, you know, has the plaintiff shown that the proffered reason was pretextual?
agreed. And I think ultimately, whether it's pretext, whether it's mixed motive, I think ultimately there has to be a question on the jury verdict form which says something to the effect is, did you believe that in this case the 3 members of the Board of Selectmen made their decision without any consideration of a prohibited motive? And on question 6 in our case, they essentially answered yes. Now, whether that could have been, you know, if this was done properly and it could have been done better with a straight pretext instruction or mixed motive instruction.
Sorry, can I just seek clarification of what you just said? Did you just say that the verdict form necessarily would have had to ask whether the defendant did not discriminate? I would have thought that the verdict form would have had to say that the plaintiff has proven that the defendant, that there was causation.
Correct. I'm sorry if I misspoke on
Which this verdict form did say, and the judge did instruct the jury on.
right, but question 6 contradicts that. So I think either way, we just
Verdiger and Lipschitz, we have a bunch of these pretext cases, and people aren't following a sort of a standard. I mean, I'm just looking, the case The case can then proceed to trial, at which point, quote, if the fact finder is persuaded that one or more of the employer's reasons is false, it may but need not infer the employer is covering up a discriminatory intent, motive, or state of mind. That's Lipschitz, which is it's been around a long time. So isn't that what is appearing in jury instructions out there, or?
I don't believe so, Your Honor. I think it really varies by judge to judge. And in Wynn versus Wynn, which was kind of a big focus in which Your Honors cite in the question on the cite for amicus briefs, I mean, it asks about Wynn versus Wynn particularly. And in that case, it specifically says, one, at the end of the evidence, it's on the trial judge to make a determination of A or B. Is it mixed motive or is it pretext? And to me, that also includes you need to decide whether it was direct evidence or indirect evidence.
Although that's now more complicated, right? Because the U.S. Supreme Court's backed away from this direct evidence in Lipschitz. I mean, in
Desert Palace.
Right, in Desert Palace, and we relied on Price Waterhouse, the concurrence. So is this direct evidence? I mean, I guess we don't have to deal with it if you both agree it's a pretext case and not a mixed motive case. We may not need to clarify that point, but a trial judge has to make that call. And I'm not sure that call is as simple as it used to be because the Supreme Court's backed away from this direct evidence.
In my view, the reason that Desert Palace really complicates things, and I think it's going to trickle down into our cases here in Massachusetts, is because in that case, what the court held was, even though there was no direct evidence, that would let a case go to the trial onto the jury on mixed motive. The plaintiff was allowed to select a mixed motive jury instruction with only indirect evidence, and that conflicts with this court's instructions on Wynn versus Wynn. And again, I think it complicated things.
Wynn versus Wynn is based on Price Waterhouse's concurrence, which Desert Palace is now poured cold water on, right?
So I think this is a good opportunity for the court to sort of set the standard one way or the other on how things should proceed in employment cases of this nature.
Okay,
Thank you very much.
thank you. Attorney Glennon.
Good morning, Your Honors. Ann Glennon, arguing for the plaintiff, Kevin Robinson. I would just like to direct the court to the fact that the town, from the beginning of the pre-trial conferences through to the end of the trial, did in fact push for both mixed motive and burden shifting. And they did that.
It never pushed for this mashup of the two, right?
No, I believe it's clear in the record. If you look at volume 5, there's pages 312, 316, 321, 463. This is all, of course, in the Mr. Robinson's papers. And then if you look at,
Read me an example of where they asked for the mashup.
they don't, so,
Just, I understand that they are objecting to all this evidence that comes in on discrimination, and then they're in a box. So then they may want to have both before the, both options available if they're being, but
Just to help out here, if you go to page 312 of volume 5, and this is repeated in a number of places, I think all the places counsel's just mentioned, this is Mr. Amos, counsel for the defendant. The only thing we ask is that the court put in our Mount Healthy defense, and that's how I think the defendant referred to it throughout, is the Mount Healthy defense. This was removed, whether there were non-retaliatory reasons, the burden shifting there. So it's very clear, I think, as you say, that they were asking for this Mount Healthy defense.
the Mount Healthy defense, I don't know if we're talking to each other, but Mount Healthy defense is not
Sounds
mixed
like it.
motive, right?
And
the Mount Healthy defense is part and parcel of the mixed motive.
But Mount Healthy, isn't that the beginning of the analysis?
It's the same decision. They're saying they would have made the same decision, which is what appears when there's a mixed motive instruction.
What
I
is
was referring, Your Honor-
what is a Mount Healthy defense, is that from
saying
the,
that- oh,
is
sorry.
that the burden shifting? Or is that the mixed motive burden shifting?
It's saying that the town, it's mixed motive. It's saying that the town would have made the same decision even if they made the decision in part because of the unlawful retaliation, which of course, if the plaintiff proves that had any part in this, particularly in a pretext case, there's still liability. I think what I was trying to direct the court to at volume 5, 321, I start out by saying, you know, we don't typically instruct the jurors on McDonnell Douglas. We've told them what causation is. We've told them that there might be other legitimate reasons to play. It's up to them to decide. And then Mr. Amos says, with all due respect, that's not the law. We absolutely instruct the jury on burden shifting. And then he goes on to say,
But there's both, their burden shifting is all part of the pretext stuff as well.
right, but then he goes on to say, it's our burden to show that there was a legitimate non-discriminatory reason by a preponderance of evidence, then it shifts back to that it's both pretext and it was motivated by animus. And I say that it's not pretext plus. And then if you take that in conjunction with what's at volume 5, 304, lines 21 to 22, when he's arguing against the inclusion in question 7 of the idea that it doesn't have to be the sole reason, which this court has long held to be true, he says, this reads very much like a mixed motive instruction, which I don't think the case calls for. So they go back
Who
and
says
forth
that?
on asking for both.
But he says that? Because that's exactly the point. But
Can I ask you about, because there's,
I'd like to just, before we leave this, I'd just like to clarify, what are you saying in that last point? Because it sounds like he's saying it shouldn't be a mixed motive there.
Right,
Why
but
does
then,
that support your position that he wanted this mix-up?
because if you read the entirety of the conference, you'll see that he goes back and forth on it. And then when they put the verdict slip, which went in exactly how they proposed it from the beginning of the pretrial way to the end, but for the addition of the sole, not the sole reason in question 7, and then the reiterations that he referred to towards the end would just simply to add the punitive damages question, which the judge decided should go to the jury to extend the lines for the amounts of the damages. But the real basis was exactly as they proposed it. And question 6 is not the determinative question. Question 5 about direct causal connection between Robinson's protected conduct and the town's adverse actions is, and when you couple that with question 7, where they were asked to find pretext, and then go even further with question 8, where they were asked to assess damages that were directly caused by an actual result of the town's adverse actions, it's clear that the jury followed the jury instructions as a whole, which made it clear more than once that Robinson's burden was but for, and which made it very clear that no damages could be awarded unless the harm was directly caused by an actual result of the unlawful adverse
I want
actions.
to ask you, if I may, a question about the jury instructions themselves as opposed to the preservation of objections. And specifically, the portion the judge re-instructed the jury on. I think you're going to see that in volume 5, pages 457 through 458. So there, the judge instructed the jury, re-instructed the jury, and this re-instruction, I believe, occurred at your request, that if you find the defendant had other alleged legitimate reasons for its actions with respect to the plaintiff, or that the other legitimate reason was the sole reason for its action, then you must find for the defendant, he says, unless the plaintiff has adduced some significantly probative evidence that the town's proffered reason or reasons was or is pretextual. Now, this is, I think, and then it says, if you find that the defendant would have acted the same, even if the plaintiff did not complain about or oppose about gender discrimination, then you must find for the defendant. You see that?
Yes.
Okay. If we are to presume that the jury instructed, that the jury followed the instruction, how is it then that there is not a defense verdict once question 6 is answered yes?
So two things. First of all, that one sentence out of the whole set of jury instructions, which needs to be looked at as a whole, not fragmentally,
Yeah.
and question 6, they weren't entitled to it because this wasn't a mixed motive case, which
This
everybody
was
has
the
agreed
instruction,
to.
right?
Right, and that's the error, that one sentence, okay? And the thing is, question 6 is not the determinative question. It's a preliminary and subsidiary question, which goes to that line. It's about the same action, same.
But then it's not a single sentence because that was repeated earlier in the instructions the same way. And then it's repeated. And then it goes on and it says, the defendant has asserted that it had legitimate non-retaliatory reasons for its actions. If the plaintiff convinces you that the alleged non-retaliatory reasons put forth by the defendant for the adverse actions are false, that fact may be used by you to infer that the reason for the adverse action was retaliation. Now, it seems to me that that might be sort of what question 7 was supposed to go to, but question 7 doesn't do that because question 7 is asked in the alternative. And it doesn't tie the finding of pretext to question 6, which asks whether it was the only reason or a reason. So I'm having a hard time, frankly, connecting question 6 and 7 to the instructions that the judge gave. And I guess ultimately my question is, why isn't that a problem?
So first of all, Your Honor, that particular instruction was repeated because of the use of an and versus an or. And frankly, I think the defendant benefited from the error in including question 6 and including the mixed motive sentence, and because it drew extra attention to their defense. And the judge in the instructions said that they've, asserted a legitimate non-discriminatory reason. So it actually directed the jury's attention to their defense, and the jury still found against them. With respects to question 6 and 7, as I was saying, question 6 is a preliminary question subsidiary to the determinative questions, which are 5, causation, and 7, pretext. And it went in there exactly as the town had proposed, with a yes or a no answer still able to result in a finding, this is to question 6, of liability, because it has them go to damages, either directly or after finding pretext in question 7. Now, the issue with question 7 is it is an accurate description of pretext, especially when you combine it with question 5, the direct causal connection. It establishes the plaintiff's ultimate burden.
But it didn't end after where the defendant, I frankly think that there may not have been a problem if the verdict form had been given in the form proposed by the defendant, because question 7 would have been limited to just asking about whether the reasons were true. But the addition of the alternative is, which I believe was done at your request.
It was, Your
The
Honor.
plaintiff's request is what muddles things up here, I think.
Not the sole reason was at the plaintiff's request, because it is one way that he can prove pretext. And that court has long held that. And in this court, in Chief of Trial Courts versus the MCAD, which cited to Lipschitz, actually said that a plaintiff does not have to specifically reject defendants' LNDRs to prevail, need not exclude all other possible explanations and prove intent beyond a reasonable doubt. They went on to hold that violations of 151B may still occur even if those reasons played some part in the decision. So it is a valid question and instruction to let the jury know that it didn't have to be the sole reason. Could it have been worded a little better? Perhaps, not in the negative, but I think it's important to note, and what I was trying to get to earlier in the DePrado case, this court specifically looked at the fact that the instructions as a whole laid out that it was a but-for burden, that the instructions as a whole laid out the fact that any damages awarded,
The instructions ever shift the burden of, in a mixed motive case, the burden of proof shifts to the defendant. But in a pretext case, the burden is always on you, right?
Correct. And
Do these, I haven't read all through these instructions yet. I've just read the excerpts that are in the briefs. Do the instructions shift the burden of proof to the defendant in various points?
they do not, only with that one mixed motive
That's
sentence.
the only time they do that.
Yes.
Okay.
And what I was going to say, in Deprato, the court made a real point of pointing out the fact that the jury found damages as a direct result, an actual cause of the adverse actions. Excuse me, I want to get the exact language here. Was proof that they found that the plaintiff had established but-for intent, because there would be no damages if they weren't caused by the defendant's actually caused by the defendant's adverse actions. I mean, as this court has said in Box Pond, a defendant
And
or a
the case
party.
you just cited, that's a mixed motive case or a pretext case?
Deprato is one like this case where it was a confused issue. I think this is certainly the opportunity.
Was that a case, though, where there was direct evidence of discriminatory behavior, which, again, that's always been the trigger in Massachusetts, this sort of direct, strong evidence of discrimination, right?
There was not. There was not. I
In
think
that
it was.
case, there wasn't, and we still got into this mess?
Yes.
Okay.
Because I think there was a mix-up on some mixed motive issues and things of that nature in there. I mean, and certainly this is an opportunity for the court to, make its final word on whether and if mixed motive should ever apply, because I think there's an argument that it should not, because the pretext analysis already
Not going
encompasses
to be
that.
very popular with plaintiffs' lawyers if that's the position you're pushing here. You want to get rid of mixed motive in cases.
I actually,
That's a valuable tool for plaintiffs in these type of cases. Now, this case is sort of a bizarre, where there, again, like the motion judge said, there's stronger evidence of the opposite of discrimination. The evidence of discrimination you have to dig deep to find and tie to a lot of circumstantial evidence, but you've got on the other side of the equation.
respectfully, Your Honor, there's an abundance of evidence about a 14-month pattern of harassing and retaliatory conduct. It's not direct evidence, and we did pursue this matter from start to finish, and it did not start out as just an age case. It had definitely multiple claims, but retaliation was always in the case, and all of that same evidence applied to everything.
And you did win.
And we did win. You're right, Your Honor. And I was going to say that this court has held in Box Pond that the party that invites the error can't not now benefit from that error because it didn't like the jury verdict, when it's clear from the whole instructions and all of the affirmative answers.
Can I go back to the very first? Tell me again why you win despite question 6. That's the hardest thing for me, because I have got a jury answering 6 in a way saying that they would have reached the same conclusion after. So explain that to me, because to me that's the hardest part of the case.
Certainly, it would be better if 6 wasn't in there, and they didn't deserve 6 because it's part of mixed motive.
6 was there.
Right.
And you didn't object to 6, right?
Oh, we did object to 6.
You objected to 6 too.
we did.
Okay, all right.
So, Your Honor, I would say in most cases, and this court could take this opportunity to decide that the verdict slip shouldn't have been so specific, but in this case, I think it helps the court to ascertain the jury's intent and the validity of their verdict. Questions 1 through 5 had the jury answer, and they answered affirmatively to each and every element of Robinson's retaliation claim. 5 being, was there a direct causal connection between the town's adverse actions and Robinson's protected conduct, although I should have said that the other way around probably. And then, even no matter how it answered question 6, yes or a no, as the town proposed, the jury was told to go to 7 and determine whether Robinson had established pretext, which they said Robinson had. maybe there's a small issue with the wording of 7, but whether the jury decided that he established pretext because they didn't believe the town's reason, which there's a lot of evidence on the record why they shouldn't. They didn't obviously credit the testimony of the defense witnesses, or if they found it because it wasn't the sole reason, and then back to 5, there was a direct causal connection between his protected conduct and the adverse actions. And then again, as I said, in DePrato, you look at the damages question, and since those instructions made it very clear, no damages unless the harm is a direct result actually caused by the town's adverse actions, I think as a whole makes it very clear that the jury found that Robinson met his but-for standard and established that his damages were the direct result of the town's adverse actions.
Okay, thank you very much.
Thank you.